Welcome to video 2 of our 3-part extravaganza on the sale of real property. This video, we're going to talk about marketable title. Now, marketable title is something we have already seen. I'm going to ask you to cast your mind back a couple of weeks ago when we were talking about what kind of language constitutes a fee simple for purposes of conveyance. Remember the case of Cole versus Steinlauf? We read this case in the context of the language that was necessary to convey a fee simple at common law versus the modern rules. In this case, the parties entered into a contract for the sale of real estate in Norwalk, Connecticut. And the contract of sale provided that if the seller was unable to convey title to the premises free and clear of any defects of title, the purchasers had the option of rejecting the seller's deed. And in this case, the attorney for the purchasers discovered that in one of the deeds in the seller's chain of title, the phrase "to X and their assigns forever" was used to convey the property rather than to X and their heirs. At the time, in Connecticut, transfer of a fee simple required the language "to X and their heirs." But remember, this transaction had been done in New York, where that language was not required. So first of all, big reminder, always check the law of the relevant state to avoid both malpractice and to avoid screwing it up for your client. You want to make sure that you're using the necessary language in the state where the real estate exists to convey what you want to convey. In this case, the Connecticut Supreme Court concluded that the buyer could cancel the transaction because the seller could not deliver marketable title. And when we talked about that case, I told you, bracket the idea of what is marketable title. We will talk about that in the future. And congratulations, now is the future. We're going to talk about what marketable title means. A number of you expressed concern in the Cole case about whether or not that seller could ever sell the property. And I told you there were some workarounds, and we're going to look at those workarounds today. But first, I want to take us back to the hypothetical we were working with in the first video between about a deal for sale between the Bakers and Stone. So let's add the fact that Stone obtained the house through adverse possession rather than through purchase. And Stone and the Bakers signed a typical contract of sale. So we've moved away from the question of the enforcement of an oral contract. Let's assume that they signed a typical contract of sale. And the Bakers are now worried about whether or not Stone can deliver marketable title when he acquired the property through adverse possession. Question is, can the Bakers get out of the sale on this ground? And the answer is that Stone may not have marketable title, because unless Stone has gone to court and quieted title, he doesn't have a deed in his name. Doesn't mean that Stone can never sell the property, just like the Cole case didn't mean that that seller could never sell the property. They just have to take steps to clear up the cloud on the title before they can sell it. And in this case, in this hypothetical, before Stone can convey marketable title, he needs to go to court and quiet title so that he has a deed in his name, and then after that, he can deliver marketable title. So we've been talking about marketable title without defining it. This definition comes to us from the Lohmeyer versus Bauer case that we're going to talk about in a moment. And it defines marketable title as title that is unencumbered and free from reasonable doubt as to its validity. The court's description, which I think is very evocative, is title that a reasonable, intelligent person who is well informed about the facts and their legal bearings would be willing to accept in the ordinary course of business. That is both really specific and really vague at the same time. And obviously, in order to understand what this means, we need to know what's an encumbrance. What does it mean to say that title is unencumbered? So let's look at what that means. An encumbrance is a right or interest in land that can exist without meaning that somebody doesn't still own the land, that they can still convey the land, but that diminishes its value or takes some of the sticks out of that bundle that we think of as fee simple absolute. So typical and encumbrances that you're likely to see are mortgages, right? A mortgage is an encumbrance on the land. A judgment lien is an encumbrance on the land, a mechanic's lien. A lease is an encumbrance on the land. We talked about how a landlord can sell property that they've leased out, but they have to sell it subject to that lease, right? They can't remove the tenant because of the sale. That means that the lease is an encumbrance that makes it, right, less attractive maybe to a purchaser. Covenants, easements, we will talk about what those are in a couple of weeks, and accrued and unpaid taxes. Those are all encumbrances that don't stop somebody from conveying the fee simple, but diminish the value of what the person who gets the fee simple actually receives. So let's talk about Lohmeyer versus Bauer, right? This is a case that directly addressed the question of when is an encumbrance sufficient to prevent the transfer of marketable title. So we have Dr. Lohmeyer, right? He enters into a contract with Bauer to purchase this lovely house that you can see on the slide. It is a single-story house, and he discovers after he has entered into this contract, as he's doing his due diligence, that there's some problems. First of all, this house is not in compliance with the HOA requirements that the houses be 2 stories. Second of all, the house is not in compliance with the zoning requirements about setbacks. Now, the problem here from Dr. Lohmeyer's perspective is that if he goes through with this purchase, he is purchasing a house that not only is subject to zoning and subject to an HOA, which would not be encumbrances sufficient to void the deal, but that the house is in violation of the zoning and in violation of the HOA requirements. And as a result, if he purchases this house, he is going to maybe find himself forced to engage in a lawsuit over the setback and maybe even be forced to modify the building to bring it into line with the HOA. So obviously he is very concerned about that and he wants to get out of the contract. The court says that, again, the fact of zoning is not an encumbrance sufficient to void the contract, but a violation of the zoning is. Same thing with the HOA. The fact of an HOA is not an encumbrance sufficient to get out of the contract, but a violation of the HOA rules is, particularly when it's such a substantial one like the number of floors in, or stories, I guess I should say, in the house. So we get back to the same question that you guys asked me in the Cole cases. Well, can these people ever sell their house? The answer to that is yes, but let's look at why and how. So here is the actual contract provision in the Lohmeyer deal. Right? Seller shall convey or cause to be conveyed to buyer good and merchantable title to the real estate by recordable general warranty deed. We'll talk about what that is. Title, when conveyed, will be good and merchantable, subject only to general real estate taxes not due and payable at the time of closing, covenants, conditions, and restrictions of record, building lines and easements, if any, provided they do not interfere with the current use and enjoyment of the real estate. Now, I want to emphasize that the buyer agreed to take this property subject to covenants, conditions, and restrictions of record building lines, and easements. Right? Lohmeyer agreed in this contract to accept the existence of the private encumbrances from the HOA. But what the court says is he did not agree to accept their violation. The violation of the two-story requirement placed him at risk of being sued. The violation of the setback zoning requirement also placed him at risk. The local zoning board could force him to pay a fine or even potentially remove part of his house. The lesson to take from that is that a buyer does not have to purchase a lawsuit. What's the seller supposed to do? Let's say you are the owner of that lovely house that is in violation of the HOA and in violation of the zoning. What do? So here's a sample from the New York contract of sale. And notice it is specifying that the premises are sold and shall be conveyed subject to zoning and subdivision laws and regulations, provided that they are not violated by the existing buildings, and then a bunch of other things. And then at the bottom says the other matters, if any, set forth in a rider attachment. That's the answer. Right? The answer to the problem that the sellers had in the Cole case and the sellers have in this case is disclosure. If you tell the buyer you are purchasing this property subject to these zoning requirements and these HOA requirements, and the property is in violation of those requirements, then the buyer can perfectly agree to purchase the property, and you, because you have told them and bracketed that out of the promises you're making, can deliver marketable title as the seller. So the answer is disclosure. Now, that might mean that the purchaser doesn't want to pay as much money, right? You might not want to pay as much money for a house that is in violation of the relevant zoning requirements as you would pay for a house that isn't, because of the risks involved. So, that's might be a problem for the seller, but the seller can sell this property and deliver marketable title by making exceptions for the encumbrances that would otherwise undermine the marketability of title. And that requires specific disclosure of those encumbrances to the seller so that the seller can take the property anyway. And here's another way to solve the problem. There are plenty of people, and you'll see maybe their signs as you drive down the street or their pop-up ads online for "we'll buy your property regardless of legal problems." Now, these kinds of offers for sure are going to be very low offers. But the point is that there is a way to sell property even if there are problems with marketable title. The question is going to be the price. So just to sum up a little bit, when does a seller lack marketable title sufficient to deliver marketable title as required by the contract of sale? First of all, when someone doesn't own the property. In our discussions of adverse possession, right, you were a little bit confused about the idea that somebody could deliver an invalid deed. Right? Somebody who doesn't own property that they're purporting to sell can't deliver marketable title to that property. So that's number one. Number two, when the property is subject to an encumbrance, then the seller can't deliver marketable title. And number three, when there is reasonable doubt about whether or not they properly own the property and whether or not the property is subject to an encumbrance. So a good rule of thumb is that title is unmarketable if purchasing it would subject the purchaser to a real risk of litigation. And again, unmarketable simply means that you can't sell it to somebody without disclosing these risks and saying, I am giving you marketable title except for, and then listing the exceptions of the encumbrances that would otherwise make the title unmarketable. If we go back to the New York form contract that we've been looking at, here's what it says about marketable title. At seller's expense, seller will deliver to buyer a title commitment for a title insurance policy in the amount of the purchase price. And the New York form contract says that a commitment for title insurance is conclusive evidence of merchantable title, which is the same thing as marketable title, subject only, again, subject only to the exceptions stated therein. So this is a slightly different approach to it, right? This is saying if a title insurance company, and we'll talk about what those are next class or the class after, right, is willing to give a title insurance policy, that means that the seller can convey marketable title. So that brings in like a third-party verifier to vouch for the marketability of title. So what about this? I would say hypothetical, except it's a real situation from somebody online, right? And so they posed a question. I have a real estate question. A real estate developer who took 1/8 interest in our farm from a cousin threatened us that he was going to force a partition by sale. So let's just stop there, right? Just a brief review of concurrent estates, right? Took a 1/8 interest means that this real estate developer bought out another co-owner. Possibly this was a farm that passed through intestate succession to the next generation. Anyway, ownership is divided up among concurrent co-owners in one period of time. And a real estate developer bought out one of the cousins and now owns 1/8 of the interest. And that as a new minority owner, the real estate developer used the threat of partition by sale to convince the other owners to sell to him. The developer, right, doing that gives the developer some control over the price, right? It's not going to be sold at a sheriff's auction, and it's not going to be sold through Zillow. It is a private transaction that the developer is saying, I will purchase your land for X amount of money, or if you don't like that, I'll go to court and I'm going to force partition by sale. Now, why did the developer do that? Because he knew of a profitable opportunity. Let's go back to the problem. Right? We sold at a decent amount, but not what it was worth. Again, being a co-owner threatening to go to court for partition by sale gives that developer a lot of leverage to get a very good price for the purchase of the rest of it. Back to the problem. My parents closed in November 2018, and we found out last week a school was going on the property, and the developer sold to the school board for 3 times what he paid us. I did an open records request, and I found he put forth a proposal to an RFP for our land and stated he had clear title. And by the way, this was submitted under penalty of perjury. Essentially, he was selling land he only had a 1/8 interest in. Did he commit real estate fraud? So here the developer, right, knew of an opportunity to profit. Had he gone to the co-owners and said, hey, we can sell this to the school board and make a lot of money, then all of the co-owners would have shared in that profit. But by buying them out, the developer captured all of that gain. So a couple of questions. Did the developer owe a duty to disclose and share that profit with his co-owners? The answer is no. There's no duty of good faith and fair dealing here. Property relationships, except in a couple of specific contexts, don't have that duty. So, and this is not a landlord-tenant situation, right? This is not a good faith obligation to consent to a sublease or an assignment. This is a purchase. This is a strong attempt to strong arm that was successful the other owners into selling. And there is no obligation to disclose information in that context. But now to the question posed in the social media post. Was this real estate fraud to promise to sell property that the developer didn't have? And the answer to that is no. A seller has to have marketable title to deliver at closing. Otherwise, right, there's the buyer can get out of the transaction. But the seller doesn't have to have marketable title to enter into a contract of sale because title is delivered at closing, not at the contract of sale. So closing is the critical moment, at which point the seller must be able to produce and convey marketable title. Now, obviously, this seller was taking a major risk by promising marketable title without owning it. But also, this developer clearly saw a clear prospect of getting marketable title before they would have to sell it to the school board. So, what I want you to take from this is the lesson that the commitment to deliver marketable title is a commitment that you make in the contract of sale to deliver marketable title at closing. That means that between the contract of sale and the closing, the seller can do whatever it is they need to do to acquire marketable title or to remove encumbrances from their title such that they can they can deliver marketable title at closing. Let's go back to our friend, the Browns, who want to purchase the Stone property again. So after signing the contract, the Browns learned that the property is worth less than the purchase price because it's located near a highway. Can the Browns get out of the contract? Can they say that that is an encumbrance? The answer here is no, right? The seller is not guaranteeing that the buyer gets a good deal when they deliver marketable title. They're simply promising that they're going to deliver title without encumbrances. The fact that the Browns misestimated how much the house is worth is not the seller's problem. And, certainly something like a highway is very obvious. And the Browns, had they done their due diligence, would have realized, oh, this house is near a highway. I wonder how that might affect valuation. So the answer again to this hypothetical is no. All right, this wraps up video 2 of our 3-video property class. The next video is on required seller disclosures. This video obviously talked about disclosures in the context of marketability of title. Next video, we'll talk about other disclosures that are required by law as part of the contract of sale.